So let's begin with our first case, 20 minutes of argument per side, Songyu versus Farm Bureau General Insurance Company.
Good morning, Your Honors. May it please the Court, Kimberlee Hillock on behalf of Defendant Appellant Farm Bureau General Insurance of Michigan. I'd like to reserve 5 minutes for rebuttal.
That'd be fine, thank you.
The Court has asked the parties to address 4 issues, but I am concentrating my oral argument on the second issue because I think under the Grosse Pointe Park case, it's clear that this is the issue that the Court has struggled with. And the issue in that case is, or the second issue is whether and under what circumstances the doctrine of equitable estoppel may be applied to require an insurer to expand coverage that is contrary to the express terms of an insurance contract. And I think the answer to that lies in the nature and the purpose of equitable estoppel. And so equitable estoppel, as its name suggests, is an equitable remedy and it's designed to rectify injustice. But as the MDTC pointed out in its amicus brief, it should only be applied rarely, cautiously, and under extraordinary circumstances. So, in other words, it's the exception to the rule. The general rule is that contracts should be enforced as written. And the rule may not be swallowed by the exception. Parameters must be set to the exception on the exceptions so that the exception does not swallow the rule. Now, according to Amjur, equitable estoppel should not be permitted to defeat the administration of law or to extend beyond the requirements of the transactions in which they originate. So in other words, estoppel should not be used to expand contracts. And this is also what was said in Rudock, which is that equitable estoppel may not rewrite a contract or a policy and expand coverage. So in preparing for argument today, I went back and I looked at, all right, well, how many cases have the Michigan appellate courts decided that have involved equitable estoppel issues? And from 1852 until 1999, there was an average of about 5 cases per year involving equitable estoppel. But from 2000 until 2018, this number jumped to almost 24 cases a year. And I think the reason for that is because of the Kirshner decision. And now, while Kirshner reiterated the rule in Rudock that equitable estoppel may not rewrite the contract to expand coverage, it also said that there was an exception to this rule. Actually, it gave a couple exceptions, but there's one in particular. When the inequity to the insurer as a result of broadened coverage is outweighed by the inequity to the insured. Now, this is really broadly written. And what that means is that the exception has the potential of swallowing the rule. And because anytime a contract dispute comes up and an insurer says, well, there's no coverage under the contract, the insurer can raise equitable estoppel as a result. But if you look at Kirshner, it actually only gave 2 examples. In the 150 years that it reviewed, it only gave 2 examples of when this inequity is outruled or is outweighed. And one is when the insurance company has misrepresented the policy terms to the insured, and the other is when the insurance company has defended the insured without a reservation of rights. Now, I would posit that the misrepresentation issue, that can always be raised as a fraud claim. It does not need to be raised as an equitable estoppel claim. And that the only exception that the court should recognize, because pretty much it only existed for 150 years, was when an insurance company has defended the insured without a reservation of rights. So that would be Farm Bureau's proposed rule. That the only time equitable estoppel may be applied to require an insurer to expand coverage that is contrary to the express terms of the contract is when the insurance company has defended the insured without a reservation of rights. And I'd only like to make 2 more points. Farm Bureau adopts the argument of the Insurance Alliance of Michigan when the Insurance Alliance of Michigan said, as far as knowledge on the part of the party being estopped, that the heart of estoppel is fraud and dishonesty. And therefore, In order to have estoppel invoked against somebody, the person the party has to have knowledge of the facts in order to misrepresent. The only other point I would make in this case is there's been much made of the fact that the adjuster's failure to convey to underwriting that the plaintiffs were moving. That's a red herring, because even if the adjuster had conveyed to the underwriting that the plaintiffs were in the process of moving, it wouldn't have changed things because they had not yet moved. And the insurer could hardly put somebody outside the insured's doorstep to see when the insured's moved. There would be no way for the insurer to know that the insureds had moved unless the insureds told them. Unless the court has any questions, I would reserve my remaining time.
Are there any questions?
Well, I guess I'll ask a question. Good morning and welcome to our October session. Help me to understand as we look at this issue dealing with estoppel and we're trying to kind of do an analysis of this. The thing that I would like to kind of have an understanding of is that, the insureds paid their claim and they kind of continued to, pay their claim. The claim was renewed without any kind of objection. Help me to understand how ultimately they wouldn't have a genuine belief that everything was what it was supposed to be.
Well, Your Honor, I think the key to that, it's not something I can put set in stone, but the fact that when the adjuster came out to the house in February of 2013, the insureds at that point, their house is all in disarray. They had actually moved out in 2010, and yet they tell the adjuster, well, we're moving. Well, why would they tell the adjuster we're moving unless they had some concern as to whether there actually was coverage under their policy because they had moved out 3 years prior to that?
Okay, and I think that what I'm trying to understand and, kind of work through as I try to kind of work through this case is the thing that when you're looking at estoppel, the thing that I'm trying to kind of grapple with, and maybe you can kind of help me through this process, is that this is the kind of situation where ultimately I look at this like you're buying a car in a certain situation, but the car doesn't really work, right? So you buy a car, you're excited about your car, but you put the car in the garage but the car doesn't really work. It's not a workable car. In this situation, couldn't it be argued, and again, I'm just trying to work through this with you so I can have an understanding of this, couldn't it be argued that ultimately they were sold a policy that they believed to be an adequate policy for their living situation when it wasn't? So it's the idea that you're kind of selling them a policy or you're selling them an item which isn't going to work. So ultimately, the insurance industry, the insurance company can continue collecting the payments. They can continue to collect they're able to receive their payments. But ultimately, it's a policy that is just not valid or even remotely appropriate for the insured based on this situation. And I guess couldn't it be argued that there'd be some facts that could show that there might have been some reasonable knowledge that ultimately there was a policy that was sold that if the policy needed to come to fruition couldn't be claimed? Just like buying a car which sits in the garage until you need it and it doesn't work. So here it's the idea is that the insurance company basically is taking the premiums. The insured thought that the premiums were for the appropriate policy that they had bought, and that ultimately in the end, when it was necessary for them to put in a claim, only at that time are they appraised and made aware that this is no longer a policy that is usable.
Yes. I guess I'm not sure I understand the analogy with the car, but
the idea of buying something, whether it's a car or whatever it is, the idea of acquiring something that when you sell it to somebody, know isn't going to be applicable or isn't going to work. And the hope is that you never need the car or you're never going to use the car, and this only becomes an issue when you attempt to use it. and now it's no longer workable. So this is a policy that was sold that really was not a policy that was designed for these folks or could be even accessed by these folks, but yet they thought it was.
Well, as far as the car goes, I think it's a little bit of caveat emptor. You purchase the car, you need to see if it's running to make sure it works. It's on you to see if the vehicle meets your needs. As far as the insurance policy goes, it's a little bit of the same thing. You have the insurance policy. You need to read that insurance policy and make sure that you're covered under that, because the policy clearly said that if the house is unoccupied for more than 6 months, there's no coverage. And they could have gotten a different policy. They could have gotten the seasonal policy, which would have at least covered them for a year. But I'd like to point out that at the time they got the insurance originally, it was in 2006. So they had coverage in the beginning. It was only in 2010 when they moved out that, they should have done something different.
So your position would be that it's really the sole responsibility of the insured, not the agent, in terms of making sure that you fully understand or know what the coverage is, even if the coverage is not applicable to what it is that you understand it to be, or that you're purchasing it for a specific reason.
In this case, I would say yes.
Okay.
Now, often an agent is an independent agent and therefore an agent of the insured, but Farm Bureau's agents are agents of the insured. They're captive agents. So they simply provide the policies that are requested.
Got it. Thank you very much, Counsel.
Are there any other questions?
Okay, thank you. You've reserved 5 minutes.
May it please the court, my name is John Nowd. I represent the plaintiff appellants Song Yu and Sang Chung. Members of the court, the plain language of plaintiff's insurance contract with Farm Bureau did not preclude coverage, but rather provided coverage for the December 2013 water damage to plaintiff's Westlake home. Farm Bureau and its amicus supporters incorrectly assert that plaintiffs are asking the court to expand coverage in this case, when in fact the policy unambiguously provides coverage for water damage to plaintiff's Westlake home. The reality is that Farm Bureau is asking this court to contract or to reduce or to eliminate policy coverage by holding that plaintiff's insured home did not satisfy the policy definition of residence premises in December 2013. In this regard, plaintiff Song Yu's affidavit and his examination under oath testimony provide uncontroverted facts which establish that plaintiff's Westlake home was not vacant and was occupied as those words are defined in the policy in December of 2013. With regard to the residence premises issue, during 2013, plaintiffs lived in with regular and continuous legal presence both their primary home in East Lansing and their second home on Westlake, just as did the other 100 Farm Bureau customers who insured 2 homes with Farm Bureau's agent Dan Griegart and who lived in both of those homes with regular and continuous legal presence. When Farm Bureau insures a second home for an insured, and that second home is not vacant beyond a period of 60 consecutive days, or is not unoccupied beyond a period of 60 consecutive months, emphasis on consecutive, then when Farm Bureau Standard Homeowners Policy Form is read as a whole, it is reasonable and logical to conclude that the insured is residing in both homes and that the second home is also a residence premises. If Farm Bureau does not consider an insured home, an insured second home, to be a residence premises, then why does the increase in hazard condition in its standard policy form provide that Farm Bureau will not be liable for a loss occurring to an insured home when the home is vacant beyond a period of 60 consecutive days or unoccupied beyond a period of 6 consecutive months? For these reasons, there should be no need for the court to address the circumstances under which equitable estoppel may be applied to require Farm Bureau to provide water damage coverage for plaintiff's second home. However, assuming arguendo that on 12/25/13, plaintiff's second home was, quote, vacant, end quote, or not, quote, occupied, end quote, then under this court's rationale in its 1998 decision in Morales v. Auto Owners, Farm Bureau should be equitably estopped from denying insurance coverage for plaintiff's water damage loss because Farm Bureau's agent Ricks knew at the time she investigated and paid plaintiff's first water damage claim in February of 2013 that plaintiffs had moved from the insured residence premises on West Lake. Her specific testimony in this regard is, and I quote, "Question, now is it your testimony that Song Yu told you that he was living in Lansing at the time?" Answer, that he was in Lansing at the time that I was talking to him, and he just said that he had moved. I wasn't sure that it was Lansing that he had moved to. In light of Ms. Rick's testimony and other evidence before the court, these facts are clear. That in February of 2013, with knowledge that plaintiffs had moved, Farm Bureau paid plaintiff's February water damage claim, and that 9 months later, in November of 2013, Farm Bureau renewed plaintiff's policy.
Counsel, good morning. I'm just trying to understand your position. Is your position that they lived in both homes, in the Portage home and the Lansing home? Is that the position, that they traveled between both and they lived in both, so that you didn't have one that was a secondary and one that was a primary, and thus that it didn't get in the way of the 60-day rule? I'm just trying to understand the specificity of your argument.
Well, what I'm suggesting is that Farm Bureau insured thousands of second homes for its insureds. And when one considers that fact, in light of the language that is in the four corners of the policy, including the word legal presence as opposed to physical presence, it's quite clear that Farm Bureau has an obligation under the unambiguous terms of its policy to provide insurance coverage for a special peril like water damage for either home. Obviously, an insured cannot be living in two homes at one time. But when two homes are insured under the terms of the standard homeowner's policy form, and given the discussions in the increase in hazard condition about what constitutes a circumstance under which coverage will not be applied, it seems clear that its insureds are living in both homes, because if they aren't, then Farm Bureau could, if it wanted, it seems to me, under this rationale, say, well, I'm sorry, this water damage you had to your home in Charlevoix is not covered because You were living in East Lansing at the time.
What if I went away for 2 months? What if let's say it wasn't my secondary home, let's say it was my home or my primary home, and I travel quite a bit, and I was abroad, and I was doing a project in Europe, and I was there for over 60 days. Would Farm Bureau then argue that I'm no longer covered?
Well, Your Honor, my response to that would be vacant is not in question here.
Right.
Vacant means the absence of furnishings, the absence of utilities, and the absence of the amenities for living. The real issue is whether or not the property was unoccupied for a period beyond 6 months. But with regard to your question, it seems to me that Farm Bureau is saying, hey, we're going to insure your residence premises, and as long as that residence premises is not unoccupied or is vacant so that we've got an increase in hazard, we're going to insure it. But if it's vacant or if it's unoccupied for a period of more than 6 months, we're not going to cover that water damage coverage, even though it's insurance coverage that is provided under the insurance policy because of the increase in hazard condition.
Got it, okay.
Can you address opposing counsel's argument that there's an insuring provision and then exclusions, and the insuring provision requires residency, and your argument that there is no residency is looking to the exclusions to give meaning to that? In other words, I'm pretty sure the policy says, if I can find it here, defined residence premises as the one family dwelling or other structures and grounds where you reside, and which is shown on the declarations page. And I mean, reside is reside. You know, the terms that you're looking to of vacant and unoccupied go to exclusions. If there's no coverage in the first place because you don't reside, why are we looking to the terms vacant and unoccupied?
Well, Your Honor, the use of, or the words which you cite are in the definitions portion of the policy. And if I might be allowed to go to my table, I could find quite quickly, I think, the insuring agreement. And the insuring agreement itself, which is only about 5 lines long and which is quoted in my brief, says nothing about reside.
It also says the one family dwelling, other structure and ground where you reside.
Yes, sir, but I was just saying that that is a definition that is in the definition portions of the policy and is not in the insuring agreement itself. The word reside is not used in the insuring agreement.
But in the insuring agreement, it says we cover the dwelling on the residence premises, including structures attached to the dwelling.
Agreed.
And so now we look to the word residence premises for a definition, which says the one family dwelling, other structures and grounds where you reside.
Your Honor,
if you don't reside, why are we looking then to exclusions to give meaning to this definition, which is right there?
Well, because those statements in that portion of the policy go to the issue of reside. And you are given a dictionary definition of reside and perhaps think, given our law, I need to look at the dictionary definition of reside. I ask that you use your common sense and look at what the policy says about occupied and vacant and apply that to the issue of whether these people were residing in this home, just like other Farm Bureau insureds who live in a second home, but who do not live there continuously, but certainly live there legally. Nobody else has a right to live in that second home. Nobody else has obligations with regard to that second home, but yet Farm Bureau insures those second homes and now wants to say, apparently, that if you're not living, I forget the words exactly, I can find them, continuously and some other adjective, well, you're not reside, therefore you don't have any insurance coverage. I just think that that's appalling. Sorry.
Thank you. Thank you, Mr. Nowd. Thank you.
Am I done? Is my time up?
Well, if you want to continue,
well, I would like to do it. I would like to continue. I do have a couple other things that I want to say. In the 2008 case of McDonald v. Farm Bureau, Justice Taylor contrasted the Michigan doctrines of waiver and equitable estoppel. Full knowledge of relevant facts and circumstances would seem to be a prerequisite to the voluntary relinquishment by waiver of a known right. However, Justice Taylor does not opine that a party to be estopped must have full knowledge of relevant facts and circumstances. Rather, the words of his opinion provide that for equitable estoppel to apply in this case, plaintiff must establish, one, that Farm Bureau's acts induced plaintiffs to believe that they had insurance coverage on their home on Westlake. Two, that plaintiffs justifiably relied upon this belief. And three, that plaintiffs were prejudiced as a result of their reliance on their belief as that they had such insurance coverage. From Justice Taylor's opinion, it seems clear that what the party to be estopped knows is not relevant unless it is defrauded. Rather, it is the actions, not the knowledge of the party to be estopped, that is relevant. And also relevant, of course, is whether the other party relied upon those facts to its prejudice. If we require full knowledge, if this court requires full knowledge, equitable estoppel is subsumed into a waiver. There's no difference. But the reason in the law that there is a difference, in one case, an insurer with full knowledge makes a decision to waive. In another, by its actions, it induces another party to believe that it has coverage, and then the insurer backs away. Thank you. If there are any more questions?
Thank you, counsel. Ms. Hillock, you have 5 minutes to go.
I would just like to respond briefly to Justice Bernstein's question about going on vacation. And I think the McGrath case covers that. McGrath recognized that people do go away from their house for extended periods of time. And what the McGrath decision said was that the key is, do you actually have a permanent residence elsewhere? If you have a permanent residence elsewhere, then this residence cannot be your residence premises. So that's the difference. You can certainly go on vacation. Farm Bureau would never take the position that you can't go on vacation. The key is, do you live permanently or regularly and continuously elsewhere that would preclude coverage for this place. So that was the only other point I wanted to make.
What's the difference between residing and living?
I'm not sure that they're...
Can I reside somewhere but live somewhere else? I mean, are they synonyms or are they different?
Well, if I
could... let me give you an example. Can I reside in Birmingham, which is my legal residence, which is where I vote, but if I'm an elected official, I live in Lansing? But I reside in Birmingham, that's my residence, but I live in Lansing. Is that possible that people do that? How would that work if you... Like I say, you represent Birmingham, but then you live in Lansing, because that's where you do most of your work.
That's a very good question. I would presume that is where the exception may come in to coverage, where if you are going back and forth all the time and you are living steadily in both places, maybe you have living arrangements in both places sufficient that you would have coverage, but that is not the case in this particular case. Mr. Song-Yu testified that he had only been to the subject property 10 times in the last year, and that he hadn't spent the night several of those times. He just went out there to, clean up the property, rake leaves and whatnot. So it was not a situation where he was living continuously in both places.
Would you care to use any of your time possibly to address the issue of collateral estoppel here? Equitable estoppel?
As far as which issue, or I'd be happy to.
I'm sorry, I thought equitable estoppel was an issue in this case, but if you don't think it's significant enough to address, that's your judgment.
Well, Your Honor, equitable estoppel, of course, is significant in this case. Farm Bureau should not be equitably estopped from denying coverage in the case. Equitable estoppel.
Why not? You've heard the other party argue why equitable estoppel should be available to his client in this case. Would you care to say why you disagree with that proposition?
Yes, Your Honor. As far as because the insurer had no knowledge of the actual facts, and it was plaintiffs who had.
He said that wasn't relevant because that conflated.
There are other cases that say that the knowledge is absolutely relevant. And I cited the Cincinnati case in my brief and several others saying that there has to be knowledge on the part of the party against whom equitable estoppel is being asserted. And as pointed out by Insurance Alliance of Michigan in their brief, the reason for this is because equitable estoppel is based on fraud or dishonesty, misrepresentation or whatnot. And you can't have misrepresentation or fraud or dishonesty if you don't know the actual facts. And it's inequitable in itself to say that equitable estoppel applies against an insurance company when they're acting based on the knowledge that they're given by the insured, and the only way they can get that knowledge is through the insured. For the insured to then turn around and say, well, I justifiably relied on the actions of the insurance company when the insurance company was not acting with all the facts.
Thank you, counsel.
Thank you, Your Honor.
The case will be submitted. Thank you.